welcome to Gracefully Graying. I am your host, Attorney Henry Gornbein. Today on Gracefully Graying, I am very pleased to welcome as our guest Dawn Schluter, who is one of the principal partners of Schluter Hughes, a very unique law firm in Bloomfield Hills, as she leads us in a discussion of ways to avoid probate. I guess you can not avoid death and taxes, but there may be some tips on avoiding probate. So, Dawn, welcome.
Thank you, Henry. Happy to be here this morning.
Well, it's a pleasure having you. First of all, why don't you tell our viewers a little bit about your background as well as the background of your firm, which I think is an amazing, unique law firm.
Thanks. I've been a lawyer now for 36 years. It's hard to believe. And my practice has always focused on estate planning and post-death administration of estates and trusts. So helping families set up their estate plans in the right way to help them. One of the things we'll talk about, avoid probate, maybe minimize taxation, make things easy on their family, but also be there for families after a passing or after an incapacity. So I've always done both. I was at a big firm for many, many years, my entire career, actually until January of 2022, when I came to Schluter and Hughes, the firm that bears my name now. We're still doing all the things that I've always done, so estate planning and estate administration. What makes us probably the most unique, at least at the moment, is that we have something called care coordination here. We have a care coordination department. We have a physician's assistant and 2 RNs that are part of our firm, and they help support our clients and their families and people like me who might act as a patient advocate for other individuals, support the needs that come along with aging, whether it's aging in place or aging in an assisted living facility or in a senior living arrangement, and really creating what I call a professional family around clients to help take care of a larger set of needs than I had traditionally taken care of at my old home, but which are super important to clients, important to avoid elder abuse, financial elder abuse, which we hear about all the time, and make sure that our clients are safe and writing their own script in terms of how they want to get older. I think that's really the mission. I believe that very firmly people should be able to write their own script, and I enjoy being a part of that process and helping support that mission for them.
Dawn, let's start with the basics. First of all, tell our viewers a little bit about what probate consists of.
Yeah, so if you've never been to probate court, it's a bit of a mystery. I do meet with a lot of clients that have in their mind, I think, the fact that if they've done a will, they're going to avoid probate. And that's not the case. The example I give all the time is if I have a bank account, I'm just going to pick a bank, it's at Comerica Bank, and that bank account's in my sole name. I can have a will naming my daughter as the sole beneficiary and as the personal representative, meaning the person in charge of my estate. But if she walks into the bank with that will and says, hey, I'm in charge, I'm the beneficiary, the bank's going to say to her, I'm sorry, but you've got to go to probate court and get letters of authority from the probate court. Once you have those, then you can come back and we'll be happy to tender those assets over to you. And probate's not the end of the world, certainly, but it's a lot more work for your family to go through. It involves probate documents, pleadings that have to be filed and submitted to the probate court. There's filing fees that come along with that. There's an inventory fee that gets paid to the probate court based on the assets, the value of the assets that pass through the probate estate. And there's certain hoops and hurdles that have to be accomplished along the way. The easier way is to try to structure your estate in a way that your family doesn't have to jump through those hoops and hurdles. but rather can present a death certificate and go about the business of administering your estate and or collecting the assets that you have without having to seek authority from the probate court. I usually tell clients that a probate proceeding would take typically a minimum of 6 months, but that can vary. It certainly could be more than that, and so one of the biggest gifts of estate planning is just making things easier on your family. And so we'll talk about that today. Avoiding probate is one of the things that you can certainly do to make life easier for those that come after you. And if I just have to go to the bank now as a daughter and say, look, my mom's passed away, here's her death certificate, I need to collect those assets, it makes everything easier. And it makes paying immediate bills like funeral bills, taxes, illness expenses, obviously much, much easier.
So, Dawn, the goal of avoiding probate is to really simplify, to avoid having to go to court, and to make an easy transition of your assets from yourself to the next generation or whoever your heirs are. So tell us, Dawn, about some built-in exit ramps for our assets.
Yeah, that's a great question to start with. So people think of joint ownership all the time. If I have a joint owner on my house or on my bank account, as long as it's joint with right of survivorship, then my surviving owner becomes the sole owner. So joint ownership is a very simple way to avoid probate. Like everything, we have to think about the pros and the cons. I usually discourage my clients from using joint ownership with their children. Either joint tenant on a bank account can walk into the bank and remove some or all of the funds. That's one of the risks. And, while we want to trust our children and think they're always going to do the right thing, sometimes there's external influences. There's things that come up that might make that an awkward situation. It also exposes your assets to, let's say I've added my daughter to my bank account and she's in a terrible car accident and is underinsured. Have I just exposed my assets to her possible potential creditors? And the answer is, yeah, her name's on my account. And so you really want, I think, in many instances, to think about how to make things simple without making things worse, right? We don't want to have any disadvantageous outcomes because we were trying to make something simple. So a solution for that kind of a bank account might be to use a pay on death beneficiary designation. They're really quite common now. Sometimes they're called POD, pay on death beneficiary designations, or TOD, transfer on death beneficiary designations. So that's a simple way to say, okay, I want to avoid probate, but I'm not ready to just put your name on my accounts now as a joint owner because they're really my assets. So that's a possible use of a probate avoidance mechanism. That would involve going into the bank and filling out some paperwork that creates that pay on death or transfer on death beneficiary designation. You can do the same thing at a brokerage house. And now for real estate, most states, although not all states, allow something called a ladybird deed, which has the same concept behind it. It's like, I like to call it a beneficiary designation for your real estate. You're not giving up anything when you create these types of beneficiary designations because you're still the sole owner. You still have sole control over the sale or the timing of the sale on a real estate parcel if you use a ladybird deed. So it's really quite friendly. Again, not every state allows ladybird deeds, but Michigan is a state that does, and many other states do as well. Retirement accounts, life insurance, we're all familiar that those have beneficiary designations that you can apply. So that's an easy way to avoid probate. I see a lot of common mistakes when people use beneficiary designations. Sometimes people put a beneficiary designation on the accounts, and of course, years go by and they forget to go back and change them. So, I'm 50 and my beneficiary is still my dad, and now I've got kids and I've forgotten to change it, that sort of thing. or we've forgotten to put in that next layer of beneficiaries. So do I have a contingent beneficiary on my retirement accounts and on my life insurance? And then probably the most common mistake with respect to beneficiary designations on retirement accounts or life insurance that I see are people who are naming minor children as beneficiaries. And I suspect we can have a little conversation about that this morning as well. I can go there right now, or if you'd like to ask that a little later this morning.
Why don't we go there right now, and then we'll circle back because I have some questions about ladybird deeds. But let's talk about minor children as beneficiaries.
Yeah. So it's very common when you get the paperwork from your, let's say you've got a group life insurance policy at work, and maybe you've got a 401k plan. It's very common, I think, for people who are working at companies to just say, well, I'll put my spouse on there first and I'll put my children in as backups. If you have minor children, that is a legal impossibility. If your children are named as beneficiaries on any assets and they are not adults, meaning 18 in the state of Michigan, there is not an insurance company or a custodian of assets in a 401k plan, an IRA, or anywhere else that will turn those assets over to the minors. They are not legally able to receive the assets. So if that's what's on a beneficiary designation, what you've just forced is the appointment of a conservator for the minor children. And a conservatorship proceeding takes you right back to probate court. The conservatorship proceeding gives the judge the authority to appoint someone to act as the quote unquote manager of the minor child's assets until they turn age 18, at which time those assets become the property. They're to be handed over to the adult 18-year-old person. And along the way, the conservator may have to post a bond. The conservator may have to ask the court for approval to use the assets for expenses. And the court may actually restrict the type of investments that the conservator can use for the minors. And when I talk to parents about that, their eyes get wide. And I've almost never met a parent that says, gee, that sounds like a great idea. Especially 18. Most parents say, well, I understand my children are adults at age 18, but most of my clients like to pick ages that are a little bit older before their children actually get their hands on a lump of cash. Now, that doesn't mean the assets might not be available to them, but there's certainly a better way to do it than through a conservatorship in probate court. The best way for parents to leave assets to minor children is through a trust, where you set up a trust during your lifetime. You name a trustee, who is a person that you trust, to manage the assets for the benefit of the minor children. And then they are directed to use the assets for the benefit of the minor children in the way that the parents instruct the trustee to do it. So a good standard might be health, education, support, and maintenance. That's a pretty common standard for a trustee to be directed by, but it could be much more specific. I want the trustee to pay for private school. I want the trustee to use the assets to permit travel, to visit extended family, very specific things that if I'm not here and I have minor children, I want the trustee to know those funds should be used for that purpose. That is just a fabulous way to avoid probate. And if there's a common disaster and both parents go, I think the vast majority of people out there that haven't done planning are headed for that, really what I'll call, it's there, but it's a cumbersome process through the probate court of having a conservator appointed, and then the outcomes of distribution at age 18 and the certain restrictions that certainly don't line up with, how parents typically feel about how they'd want their assets to be used if they weren't here.
Dawn, let's circle back to the house. And you discussed the ladybird deed. And, typically husband and wife will have own a home, joint tenants with right of survivorship, and once they're both gone, does a ladybird deed take effect then? And my question would be, is a ladybird deed recorded or is it held until someone passes away?
Yeah, those are good questions. The first one is, yes, if it's a husband and wife and they own the property jointly, the ladybird deed can be crafted so that it only transfers to those next in line people, whoever they are, or it could be a trust as well, after both spouses are deceased. So it comes to life, if you will, only after the death of the survivor. So the survivor's still in control, can sell the property, it wouldn't have to ask anybody for permission. Nobody else has the ability to touch those assets. It's just like a beneficiary designation. I can take it off, I can change it, they're still my assets. The second part of the question on recording a ladybird deed, I suspect that practitioners, based on what I see, I think practitioners vary a bit on whether deeds should all be recorded or some be recorded and some not. In my practice, I have traditionally taken the approach that if we're going to do a deed, we should record it because the deed is effective on signing, and the recording just makes it so that if the original goes up in flames or we can't find it, it's now been recorded. So there's no risk of having done the work, but then not gotten the benefit of the work, if you will. So I typically would record those ladybird deeds. I think there's other practitioners that might weigh a little differently on that, but that's always been my approach, unless there's something, really short term that would impact that. A good example would be husband and wife, have their house in Troy and it's listed for sale. They think they're going to sell it in the next few months. Okay, well, let's just do that deed. And as long as it's sold, we're not going to go ahead with the recording. But we've got that as that safety device. So I might have a few exceptions to my general rule, and that's kind of an example of one.
Dawn, should we plan for incapacity? There's an old saying that people plan and God laughs, and we never know what's going to happen next.
Yeah, the answer is absolutely. Statistically, there's a very high probability that all of us will have some period of incapacity before we pass away. I should know that statistic. I don't know it right offhand. It's a little bit higher for women than it is for men, is my recollection. Our care coordinators carry that data in their head, but it's better than 50%. It's a very high probability that we'll have some period of incapacity. We might regain our capacity, or we might not. And planning for incapacity is a huge piece of what we try to focus on when we do estate planning here. It's just as important in my mind. You want to tell us who should be in charge if you can't handle your own financial affairs or make your own medical care decisions. And there's all different shades of gray when it comes to being able to handle affairs. Some of my older clients have handled their affairs quite successfully for their lifetime. And, they're now 90 and they still have their marbles. They still have capacity. But, everything gets a little harder. The way I explain it to clients is when I was, in high school, I ran a 7-minute mile. And then when I was in college, I, got a little slower. And when I was in my 30s, I got a little slower. And when I was in my 50s, I was happy to run a 10-minute mile. And now I'm just happy to be out there with my shoes on. So, check writing, bill paying, keeping track of, life has not gotten simpler with the passage of time. It's only gotten more complicated, I would say. Everything's online. Sometimes you can't even get your statements by mail anymore at certain places. So I have clients that say, I'm going to turn over that bill paying now so I don't end up in a triage situation. I'll still be involved, but I'm going to let somebody else do some of that heavy lifting. On the medical side, that's, really governed. No one's going to take over till you have 2 doctors certifying your incapacity, but you certainly can have helpers around you, like a care coordinator, to help manage caregiving or make your house set up for success or whatever it may be. If you don't do that kind of planning, what happens? If you lose your capacity and you don't have somebody in charge of these roles, you're back to probate court. You're back to the conservatorship. A conservator can be appointed to manage your financial affairs while you're alive, just like they can for a minor. And a guardian can be appointed for you to handle your care decisions if you can't handle those care decisions yourself. But that process for an older person is, I think, particularly difficult. First of all, there's a timetable that the probate court operates on. So if I need to have a conservator appointed on short notice, it's very difficult to get the court to grant an emergency petition in the financial arena. Everybody's going to be waiting to get paid. The petition might take 4 to 6 weeks to get heard, could be more. I mean, the court is now in control of this process, and the process is there to help, but it's not streamlined in a way that you can make your own situation streamlined. The court is going to go through checks and balances to make sure that someone's not trying to pull the carpet out from underneath a person, for example. They're going to make sure that you are a person who needs this kind of help. The court can appoint the person who's petitioned the court, or the court can appoint somebody else. The court can appoint a lawyer, somebody that you don't know and have never met. The court can hear disputes between family members. One of the, famous pieces of litigation I was involved in at the front end of my career, there was a elderly couple. The mother, the wife in the couple had clearly lost her capacity. The husband was physically having difficulty, but still had mental capacity. He was told by the care facility that his wife was in that he would need to get appointed as a guardian for her. I think the reason for that was that they saw he had some troubles, and the son was there and in the environment, maybe giving some other instructions that weren't aligned with the father. And so rightfully, the care facility said somebody's going to have to go to probate court and get appointed as a guardian. So the father filed the petition, the son contested the petition, and they litigated this issue. And ultimately, the probate judge appointed the son, finding that he was more fit to do the work. I think it really revolved around the father was very angry and didn't present very well in court, and he was very feeble. Physically, he was very feeble. He lost the ability to make healthcare decisions for his spouse, and he called us and asked to revise his estate plan. And he disinherited his only child and left his $4 million estate to the state of Michigan. And that resulted in another decade of litigation. And so to me, this was very early in my career, just the lesson of just tell us while you're alive and well who you want to have. If the wife had only had a power of attorney and a patient advocate in favor of her spouse, this whole thing would have never happened. And it's a kind of a tragic ending to a family story, really. Nobody wants that. The do better. We should all do better. While we're alive and well, tell the world who we want to be in charge, and we're going to avoid the uncertainty of probate court, the cost, the time delay, and we're going to avoid the potential for litigation between family members who actually might all be well-intentioned but have different views of the world. And I think that's really what happened in this couple. You know, went all the way to the Michigan Supreme Court.
Sad. Dawn, what about blended families? I mean, more and more common with divorce and remarriage and deaths and remarriage. What about issues of blended families?
So all the more important for partners in a marriage that have blended families, all the more important to tell us while you're alive and well who should be in charge, what you want to have happen, who gets what. Again, that's a scenario where it's just ripe for, well-intentioned family members thinking that they're the ones that should be doing these certain jobs. And if you tell the world in black and white and you've got a lawyer that did the documents, now we've taken the uncertainty out of it. It's very important. You don't want your legacy to be the litigation that happened after you left the world.
Dawn, what about the problems with good intentions?
Well, sometimes good intentions are really good intentions, and people hear different things, right? I thought Mom wanted life support. No, she didn't. And this is the poor case of Terry Schiavo. Those of us that are old enough to remember her down in Florida, the family, the parents thought one thing and her spouse thought something else about life support, and they ended up litigating over whether life support should be removed or not, and whether we, no matter how we feel about that issue personally, every one of us agrees we would not have wanted to be Terry Schiavo. There were cameras in the courtroom. It was on the news. There were cameras in her hospital showing her on life support. It's just, we can take that out of the equation and avoid the possibility of our family having heard different things at different times, or creating their own stories about what we wanted. Death is a very emotional piece for everyone, and for the family that's left behind. And the gift of estate planning is trying to make things easier on the people that are nearest and dearest to you.
Well stated. Before we sign off, do you have any final thoughts for our viewers?
Well, I hope I said it as clear as I can. Estate planning should be on everybody's to-do list if they haven't done it already. And it's not one and done. People should go back and review plans and make sure that they express their current desires and current wishes. The answer is estate planning. I mean, I couldn't say it any stronger. It's a gift to the family.
And they should be reviewed at times of births, deaths, remarriages, divorces, and these are important points. Dawn Schluter of Schluter Hughes, I want to thank you so much for being our guest on Gracefully Graying. I want to thank our sponsors and, of course, Bloomfield Cable for making Gracefully Graying possible. Thank you. Thank you so much.